Good morning. I am Sutter Selleck, and I am a member of the Contra Costa County Bar Association Board of Directors. On behalf of the CCCBA, I would like to welcome you to the 27th Annual MCLE Spectacular. We hope you are enjoying today's programs. This session, The Conservatorship of Britney Spears, The Practitioner's Take, is presented by the Contra Costa County Bar Association Elder Law Section. Our sponsor for this session is Home Care Assistance. I would like to introduce Francesca Vogel, the Director of Home Care Services for Home Care Assistance of Alamo, who would like to say a few words.
Thank you so much. I'm so excited to be here today. Good morning, everyone. I'm Francesca Vogel again with Home Care Assistance. I'm the Director of Home Care Services, helping seniors and families navigate the complex world of elder care. My passion for seniors comes from being raised by my grandparents. I've worked in home care for over 28 years, and I've partnered and worked with many of you here today. I'm on the Professional Advisory Committee for John Muir Health. I'm the Board President for Mobility Matters, providing free rides for seniors in Contra Costa County. I have 2 pet therapy minis that I bring around to senior communities, and I have a dog, Roman, who is a pet volunteer for hospice. At Home Care Assistance, we provide premier in-home caregiving services with nursing assistants and home health aides, anywhere from 4 hours a day up to 24 hours a day of care. Our client care managers are what differentiates us. The role of a client care manager is to determine the client's needs. They provide that initial assessment to find the best caregiver match. The client care manager develops a care plan accordingly. The role is to provide close oversight and supervision of the care plan and of our caregivers. Also, our professional care managers provide geriatric assessments to evaluate care needs, including determining capacity. We have offices throughout the Bay Area and throughout the country. And again, thank you so much for having me here today as a sponsor. I'm proud. And if you need me, please call me anytime. My number is 925-989-6877. Thanks so much.
Thank you, Francesca, for your sponsorship and continued support. Our event and program sponsors are a very important part of CCCBA community. They make it possible for us to provide events like this. Please support us by supporting them. Now, a couple of quick reminders. For assistance in any technical difficulties, head to the FAQs tab on the event's main page. And don't forget, while this program is pre-recorded, the speakers are available live in the chat to answer your questions during the presentation. They will also be available for a live Q&A immediately following the presentation. At this time, I would like to pass the program over to the Elder Law Section President, Demiris, who will introduce his fellow speakers. Thanks.
So much, Sutter. Really appreciate being here. We are thrilled today to present this conservatorship MCLE involving Britney Spears situation. It's my pleasure and honor to introduce Kathryn Schofield, who is a member of the board and will be presenting first. I will be presenting next, and then followed by the other presenter, Douglas Housman. Thank you very much.
Hi, everyone. This is Kathryn Schofield, and I'm presenting the first part of this presentation of the Britney Spears show, the Conservatorship edition. I'm just loading up my screen. So if you haven't heard, Britney's been in a conservatorship for the past 13 years and finally wants out. She's gotten a lot of attention, mainly around the idea of, here's a 39-year-old woman, what the heck does she need a conservatorship for? They're for old people. Well, and people don't think conservatorships are particularly sexy, but this one is, not only because it's about Britney Spears, but because it raises a lot of really important issues, starting with due process and self-determination and court supervision and attorney ethics. So we thought it was an appropriate vehicle for talking about the big issues of conservatorships we as practitioners face. So this is me, Kathryn Schofield. I'm presenting this with Demiris and Doug Housman. We are all conservatorship attorneys that practice in this area in Contra Costa. So the way this is going to work, I'm going to talk first, providing the background of Britney's story, and then what the court also considers. Then Costa is going to be addressing the conservatorship process and issues from the petitioner's standpoint. And then Doug is going to present it from the conservatee and the conservatee's attorney standpoint. We've got a packet of materials which is going to include a lot of the documents from Britney's case. We can't really get through all of it on the screen now because we have limited time, but there's a lot of reading, a lot of really interesting material there. And at the end of this, if there's time, I'm going to touch on what the new legislation is that the governor just signed, which is a revamp of a lot of the conservatorship process. So for those of you who've been living under a rock for the past 25 years, Britney is a very, 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 very famous pop star, probably one of the most famous ever. And she's gotten a lot of public attention and paparazzi attention for a lot of her antics, primarily in the early 2000s. Important to this storyline, her father, Jamie Spears, and Lynn Spears are divorced, and Jamie Spears is a big player in this. He was not around that much during her younger years. He had a bankruptcy. He was by trade, not anything having to do with finances. He was a struggling chef. And he also has a background of being an alcoholic. So he's not really the first choice that somebody would think of to be somebody's conservator. Now, around 2007, Britney went through a very public divorce from Kevin Federline. They had 2 kids. She lost custody of them because of her erratic behavior. She had a very, very public breakdown. And you might remember it because there was a very famous photo of her where she shaved her head and was attacking the paparazzi, literally attacking it with an umbrella. That happened near the end of January 2008. On January 31st, 2008, Jamie 5150'd her, and that means that she was under a temporary 72-hour hold for psychiatric issues. There was concern that she was going to be at risk of hurting herself or others. So the very next day, February 1st, Jamie files for conservatorship. Things are happening really fast. He files for conservatorship, but it's a probate conservatorship, which is odd because that doesn't normally fit with somebody who's got mental health issues. That has a whole different kind of conservatorship process that actually has a lot more due process protections. But for whatever reason, he filed a probate conservatorship for the person and the estate. He proposed that he would be of the person, and that means he would be in charge of personal decisions and healthcare decisions. And then for the estate, he was going to serve with a private fiduciary, presumably because he doesn't have a financial background. So then it's important to note also he's filed for a temporary as an emergency situation. He filed for a good cause exception to notice, which means Britney had no notice that she was going to be conserved before it happened. And the reason why they did this was because there was a third-party guy by the name of Sam Lufty who supposedly had sort of come in and taken over her life. He had control over finances, he had control over personal decisions, and the parents were concerned that he was unduly influencing her and abusing her. And they figured that if they told Britney about this, it would ultimately mean that they were telling him, and that would blow up the whole plan. So on the 1st of February, the court granted this temporary conservatorship and set up another hearing just 3 days later. One of the other things that happened in this hearing that's really important on the 1st was that the court appointed her court-appointed counsel, last name of Ingham, Sam Ingham. And she had no say in who it was that was going to be appointed for her. And it seems like the court had a private list of frequent flyers in the courtroom, and he was on that list. And so he was up. Now, what's really remarkable in the court granting this and granting the petition for conservatorship, Sam is getting paid $10,000 a week for doing this job. Jamie's getting paid $16,000 a month and has the ability to enter into contracts for her, which include provisions for his additional compensation. And based on one report, he was making something like 1% on all of her net income, gross income, which is in the course of the next decade, hundreds of millions of dollars. So he gets 1% of that. Clearly, there are people who have incentives, financial incentives for keeping this conservatorship going. So on February 4th, the court hears the next stage of this conservatorship. It's still in the temporary part, but presumably Britney had notice, and she was able to bring in an attorney by the name of Streisand, who said that he was representing her. The court, relying on Sam Ingham, who has a financial interest in staying involved, determines that Britney doesn't have the capacity to hire her own attorney, so the court's going to stick with Sam Ingham. And Sam provided some sort of medical record to support that, but ultimately it was something that the court relied on him to determine. So the other thing is Ingham was also authorized to accept service for Britney. So that way she never had to appear in court, and there's no way of really knowing what she knew and what she was informed about the rules of a conservatorship. And then from there, for the next 10 years, it was a fairly quiet conservatorship. She's working like crazy, bringing in hundreds of millions of dollars with the world tour, and she has a Vegas residency at that point, and it's all, there's nothing that's really happening in the court for 10 years. But then things start falling apart. So Britney went from back to back from being on a world tour to starting yet another Las Vegas residency. And based on the stress of that, it seems like she broke. And it's hard to say exactly what happened, but the residency was canceled very abruptly. And in March, the private fiduciary that was serving with Jamie as co-conservator of the estate, quits. Not only that, Jamie then puts her into a locked facility, psychiatric facility, and the medications are changed to be more severe. All of a sudden, she's getting lithium, which she had never received before. All of this time, Britney's never expressed much opposition to the conservatorship. There's been some public statements that she's made in interviews that say she is unhappy, but she's never brought any concerns to court. In May of 2019, she goes to a court hearing, and this is really the first time that she's ever expressed any desire to have her father removed or anything about the conservatorship changed. And then in September 2019, Kevin Federline gets a restraining order against Jamie, creating a conflict between Britney and Jamie because the restraining order has to do with her kids, protecting her kids against Jamie, their grandfather. So at that point in time, the court replaces him as conservator of the person. He gets replaced with a private fiduciary by the name of Jody Montgomery. Later that year, he files for a fee petition somewhere in the range of about $500,000. And he also has an accounting due. And then the pandemic comes. And so there's nothing that happens in the case until the following August when he actually files for his accounting. And then fast forward a little bit more, in February 2021, that's when the Framing Britney Spears documentary appears. And this is where it really captures the public's attention that there's something going on with Britney in this conservatorship. And that's when you see a lot of the Free Britney movement stuff show up in the press. Now in June, this is a hearing that got a lot of attention. It's really the second time that Britney's ever appeared in court. She called in, and this is the very, very first time that she's made a public court appearance stating that she wanted to get rid of her father as a conservator. She wanted to be able to hire her own attorney. She wanted to terminate the conservatorship if it had to continue. She made allegations that she was being prevented from marrying and having kids and just driving in her car with her boyfriend. So that was a pretty remarkable statement to make. And the court set another hearing in July, at which point she had an attorney that showed up for her. And the court approved that she could be represented by separate counsel. And she relieved, the judge relieved Sam Ingham from his duties. And from there, the conservatorship is really in the stage of the beginning of the end. Britney's attorney hits the ground running and files a petition for Jamie's suspension and removal. Jamie then petitioned as sort of a counter move to terminate the conservatorship altogether for tactical reasons. And then ultimately, just on September 29th, 2021, the court suspended Jamie and replaced him with a CPA. So where it stands right now, there is a temporary conservator of the person, that's Jody Montgomery, and a temporary conservator of the estate, the CPA. There's a hearing in November that's set so that the court can determine whether or not the conservatorship should be terminated entirely and what process that would go through. So overall, what the questions that are raised by this conservatorship are, if Britney could work, how could she possibly need a conservatorship? And even if she has a mental illness, why can't she make her own decisions about getting married and having children, or even hiring her own counsel? And how could Britney not have the right to marry or have kids or refuse medication? Why didn't Britney's court-appointed counsel get her out of the conservatorship if she was unhappy with it and seemed to be able to function as high a level as she was? And why is Britney paying for Jamie's fees and everybody else's fees, probably millions of dollars in fees over the course of the 13 years? And ultimately, why didn't the judge just terminate the conservatorship sooner? So thinking about what a court is doing, what a judge is doing when a conservatorship is petitioned for and is in front of them, there's really a core set of determinations. Is the conservatee able to properly provide for personal needs, for physical care, health, food, clothing, shelter? That's one. That's for the person. For conservatorship of the estate, the question is the conservatee substantially unable to manage financial resources or resist undue influence or fraud? There's other considerations as well. Is there any medical treatment that the conservatee can give informed consent? Or ultimately, what the court is looking for is are there any other alternatives? This should be a last resort. The term of art is this the least restrictive environment for the conservatee? There's a rebuttable presumption for every conservatee, Britney included, that they have capacity to make these kinds of decisions. So the petitioner has to show by clear and convincing evidence that the person can't provide for themselves and make these kinds of decisions. So for Britney, the court must have decided that she did not have the ability to make those decisions by clear and convincing evidence. And what the court relied on for making those decisions, even though we may not know the details of what was presented to the court, we know the inputs. There's the petition and any declarations from any interested parties that went along with it. If there was objectors, there's those filings as well. There's a bunch of confidential forms and information that the court gets. There's a court investigator who reports after interviewing the conservatee and other people as well, family members. There's a court-appointed counsel report. There's a capacity declaration from a physician and perhaps an expert physician report as well. And one thing that we do know for Britney is that she never once objected to the conservatorship. The court-appointed counsel never presented any kind of objection by her to the court. There were no objections anybody filed as far as Britney's conservatorship. So this court did what courts do. If there's no objection and there's evidence to suggest that the conservatorship is necessary, the conservatorship is going to get granted. Once the conservatorship is granted, there's really not many opportunities for the court to review what the decision was. Is it still an appropriate choice for the conservatee? If it's going smoothly, the only thing that a judge is going to see is a petition for an accounting and for fees. And once it gets going, that's usually every 2 years. Here, in any typical conservatorship, there's usually not a petition to terminate, and a judge can't just terminate a conservatorship without a petition. So Britney actually summed up what the issues are here pretty well for herself in the June 2021 hearing, where she said, "I don't think how the state of California can have all this written in the court documents from the time I showed up and do absolutely nothing, just hire with my money another person and keep my dad on board." And now I'm going to toss it over to Costa, who's going to present his portion of the program.
Thank you so much, Kathy. Great job. I really appreciate you getting the nuts and bolts of this process explained in such a great manner. This is a situation where the petitioner, Jamie Spears, he's called Jamie, his legal name, I believe, is James Spears, had pretty much been either advised or discovered that there was a way for him to get a type of control to protect his daughter in a manner that he felt was best. And so he went about it by filing with a probate code petition. But as Kathy was stating, there are restrictions and a way to do it. So why did he do it? And why did he go about it the way he did? Probate code sections 1800 and 1800.3 are illustrative as to the manner in which legally a person can go about a probate conservatorship. Probate code section 1800 shows that there are actually very limited powers and very specific needs that must not be met in order to allow for a conservatorship. So the legislature obviously does not want to go around imprisoning people or limiting their rights unless it is the last resort. Conservatorships have often been called a avenue of last resort if there are no less restrictive alternatives in place, and I'll touch upon that shortly. The goal by the legislature in getting these conservatorships completed are to protect the rights of people who are placed under the court's power through a conservatorship. And by doing so under subdivision B, it's to allow for an assessment of the needs of the person in order to determine the appropriateness and extent of a conservatorship, and actually to set goals for increasing the conservatee's functional abilities to whatever extent possible. This is a cornerstone of conservatorships that often gets overlooked, which is, why are we doing this? It's not just to, so to speak, bag them and tag them. You know, we want to make sure that whoever is conserved is provided a beneficial situation that can enhance and potentially increase the functional abilities of the individual being conserved. Subdivision C states that we also, as practitioners and members of the public involved in these matters, want to ensure that the health and psychosocial needs of the proposed conservatee are met. So in a situation like Britney Spears, we want to make sure that we have a situation where you have the health needs that Britney needs met and the psychosocial needs met as well. And it does appear from a lot of the stories, the documentaries, that was actually not even on the radar in a lot of ways. I believe one of the documentaries suggested that a geriatric neuropsychologist was involved in evaluating her, and that one of the boxes that were marked on the forms dealt with dementia findings. So, that would not be proper had it been done the right way. Subdivision D talks about a community-based service situation used to the greatest extent in order to allow the conservatee to remain as independent and in the least restrictive setting as possible. Again, with Britney's situation, we are not provided any information at all as to a community-based service that was provided to her or anything that allowed for her to remain as independent as possible. We do know that she works. We do know she was under a lot of stress. Beyond that, it is not quite clear what other services were provided to her, and perhaps had those been provided to her earlier in the 13-year process, perhaps the reign of conservatorship would have either ended or been ameliorated a lot sooner. Subdivision E talks about providing periodic review of the conservatorship by the court investigator to consider the best interest of the conservatee. In this case with Britney, it is unclear what exactly was going on with the court investigation process. Normally, if a person is improving, if a person is not in need of a conservatorship, if all their basic needs are being met, then that would be reevaluated. That takes us directly to subdivision F to ensure that the conservatee's basic needs, and I'll repeat that again, basic needs for physical health, food, clothing, and shelter are met. A lot of people, James Spears in particular, may have had a rather grandiose idea of what it meant to provide for the needs of Britney. He may have potentially believed that her physical health, her food, her clothing, and shelter were not properly being met. But the question is not whether they were properly being met, whether the basic needs for her physical health, food, clothing, and shelter were being met. And what it appears from all the documentaries that I've seen, as well as the reports that have come out, that at no point in time was Britney left without food. At no point in time was she left without clothing, although she did have some episodes. At no point in time was her shelter not provided for, and her physical health, for the most part, other than early on when she had a 5150 episode, which we'll deal with later, seemed to have been met. So, and that dealt more with the psychiatric effects rather than her physical health. So for subdivision F, those are critical points that should be provided careful consideration. Finally, we go to subdivision G to close it out. The duties that we have when we practice and we do this, as well as the judges in adjudicating these matters, is to provide for the proper management and protection of the conservatee's property, real and personal. So in this regard, this is where it appears a large part of this conservatorship was driven, that there were allegations, as Kathy had stated, concerning the manager, concerning those around Britney, whether or not she was able to protect herself from certain types of things and provide for the proper management of her assets. Probate Code Section 1800.3 is one of the linchpins to conservatorships. Those of us who practice in this area know there's no real point in pursuing a conservatorship if there are less restrictive alternatives available and or in place. And as the petitioner in a situation like this for James Spears, it begs the question, were there less restrictive alternatives available and or were there less restrictive alternatives in place? It does appear that that is a silent response that has been provided. We don't know what, if any, estate planning that Britney had in regards to naming a power of attorney, an agent who would be acting for her. Obviously, celebrities and people of high status tend to have powers of attorney, tend to have agents, tend to have managers, but it does appear that the biggest issue was who was in charge rather than the mechanism involved. Probate Code 1800.3 deals with the mechanism, and that's the large part of it. So subdivision A talks about if there is the need to establish a conservatorship that is satisfied, that the court can appoint someone to be a conservator of the person, the estate, or both. And then that's, part one. And then part B is that no conservatorship of the person or of the estate shall be granted unless the court makes an express finding that there really is no less restrictive alternative needed for the protection of the conservatee. So, it really should require a heightened standard of analysis and not just being glossed over. Does this conservatee, does Britney have anything less restrictive that could satisfy her needs being met? Is there any other form of protection available? And if the answer to that is yes, then a conservatorship really should not be pursued. And if it is pursued, it really should not be granted. Britney's case study, as was alluded to earlier and discussed, is that she worked, and most conservatees do not. She was alleged to be having extreme behavior and bizarre behavior, and those are things that are very fact specific. I mean, some of the things that we saw in the news were, her shaving her head, or for someone like me who, likes to have short hair, calling it a short haircut. She was showing off body parts, driving past red lights. These are all allegations that were made, entering into contracts that may have favored sketchy people or people who were not the people who her parents would have wanted. Her parents even, I believe, hired a person to be a spokesperson for the quote unquote Spears family because things had gotten to a point where they felt that apparently Britney's image was at risk given some of her behaviors. There were allegations by others that she was alleged to be doing drugs, whether that is prescription over the counter or other. And she was placed under a Welfare and Institutions Code section 5150 psychiatric hold for 72 hours because of her behavior. That is a type of a hold that happens for a person who is considered gravely disabled or at risk of causing harm to themselves or to others. And what is interesting about that is that takes us normally down a path towards what is known as an LPS, or Lanterman-Petrus short conservatorship, which is at a heightened standard beyond reasonable doubt. There's also a right to a jury trial in those types of conservatorships and other protections in place. That being said, that is not where James Spears and his legal team went. So the question is, why didn't Britney Spears go through an LPS conservatorship and instead went through a probate conservatorship? And I posit it was that strategy. I think most practitioners would say yes. The reality is most courts in a situation where a person is considered gravely disabled, subject to 5150s and psychiatric holds, tend to push them to the LPS part of conservatorships rather than probate. Sometimes you do have probate conservatorships in courts that try to stretch it out, as I stated in the slide, to do what they consider a good thing when they want to expedite things or when they believe that the LPS system would not suffice or be the way to go. An LPS conservatorship is something normally that is done by the county, and the county through the public guardian brings forth the case, and the county normally doesn't bring cases that it wants to lose and spend tax dollars that go nowhere. An LPS requires a jury trial. Otherwise, the only way to, so to speak, confine or restrict Britney is to get a 5150 hold, as we were just discussing, for 72 hours, or a subsequent 5250 and thereafter 5350. And that usually has to be done by a police officer or a medical care provider, someone who can observe and declare under penalty of perjury that the person is in need of this care because they are essentially a threat to themselves or to others. And 5150 is defined as, quote, when any person as a result of mental disorder is a danger to others or to himself or herself or gravely disabled. So in this situation, it does appear that Britney's dad, the petitioner in this instance, and his lawyers, when likely discussing this and thinking about what to do, likely said they did not want to go to the county to handle this as an LPS conservatorship. They likely wanted to avoid having a public defender, attorney type assigned who would zealously advocate to the end on something for Britney. They likely wanted to avoid a beyond a reasonable doubt standard, which is the highest standard in the land. Clear and convincing is the standard for a probate conservatorship. So you go from essentially a near 99% standard that you have to overcome to something that is substantially less. And if you have an attorney, such as in Britney's case, you can avoid a jury trial if there's an agreement. And you can, in a situation with an LPS, without an LPS, have what Kathy talked about earlier, which is essentially a friendlier type of an environment versus a strictly adversarial one with an LPS. The other thing to note about an LPS conservatorship is that if the person is no longer considered gravely disabled, if they improve, if they are in a position where they can make any of these basic decisions or provide for their basic care, and the law makes clear that there is no longer an LPS conservatorship that is warranted. And a lot of practitioners call it the revolving door policy because people with mental health problems improve when they're under supervision, and when they're let go, they devolve and come back into the system. That may have been another consideration by the James Spears team as to why not to go the LPS route. Instead, they went with a no notice ex parte to appoint Britney's dad, who by all accounts was not close to her, according to many of Britney's close confidants and people who were interviewed in documentaries. So, and the standard for the no notice ex parte was merely a good cause standard, which is actually less than the clear and convincing evidence standard, which is at a general conservatorship hearing or trial, not to be confused with a permanent conservatorship, which does not exist. That is a faulty statement that the media sometimes or people generically like to give to a general conservatorship. For those of us who practice in this area, we know there is absolutely no such thing as a permanent conservatorship. So, this was a situation where if there was going to be the easiest route to take to conserve a person such as Britney, James Spears' advisors would have likely advised him that you want to go with the conservatorship, probate conservatorship, go ex parte, no notice, good cause standard, and you can actually have a good cause exception to providing notice to the people who otherwise would have been provided notice and have had an opportunity to object, whether or not it was Britney or relatives or even interested persons. Now, this leads us to how did James Spears, after 13 years, decide, which he has apparently, to try to terminate the conservatorship? It appears that now he wants to step aside and leave this to Britney as an independent person. So the question is, what changed? There are some rumors and suggestions, as Kathy was talking about, that James Spears was able to essentially create a fund for himself by entering into contracts where not only was he making money as a conservator based on doing conservatorship work, so to speak, but also entering into contracts where he got other funds as well. So these are some allegations that have been made, and perhaps an observation by him over time that there was a change in circumstances, such that Britney was now able, or in his mind, substantially better at providing for her own independent needs for food, clothing, shelter, or medical care, and or that there were pieces of the puzzle in place that made her substantially able to manage her own finances, resist fraud or undue influence. So to his credit, he started a process that seemed to be something to help protect her. How it lasted this long, as Kathy stated, likely because there were no objections for a long part of time during this. And what has changed, Britney has began to have others as well as herself speak up about this, and it does appear that that has led to James Spears, whether voluntary or involuntary, re-examining the need for this conservatorship. So that's the end of my show. I will now pass everything over to Douglas Housman, who will carry the baton and do a great job. Douglas, you're up.
All right, thank you very much. All right, folks, I'm gonna just jump right into it, and we're gonna talk about three main sections of Britney's conservatorship, starting first with whether this conservatorship is toxic and what is Britney's rights as a conservatee. There's been a lot of talk by my fellow speakers with regards to how this has lasted so long. Why was there so much silence by Britney and or through her court-appointed attorney? Was Britney ever advised of what her rights were? A lot of this, as you know, we don't have the details. We're speculating, but let's figure it out. So the first document, obviously, that's cached is what we probably have all seen very often, but never really looked at and examined, and that is the Notice of Conservatee's Rights. It is a mandatory judicial counsel form, meaning that it must be filed in every conservatorship when a conservatorship is granted. And if you actually sit down and read this, you will note that there are a number of rights that are preserved to the conservatee unless the court and or the conservator has specifically requested otherwise. If you look at the bottom of the first page, obviously the conservatee is able to be represented by an attorney, is able to ask the judge to replace the conservator, to end the conservatorship, to make a will, to receive his or her salary, and also to obtain an allowance. And then if you turn to the second page, this also goes into detail with regards to, personal mail, right to marry or enter into a registered domestic partnership, receive visits from families and friends, make their own medical decisions, and then also kind of a catch-all, enter into transactions to the extent reasonable to provide the necessities of life of the conservatee or their minor children, et cetera, et cetera. Now, what is alarming here is a number of these conservatees' rights that are on this document are in the spotlight with regards to Britney's conservatorship. You've heard rumors or murmurs or declarations from third parties and or Britney herself regarding her, knowledge or thought process of whether she could marry or could not marry, whether she could have children, whether she could hire a private attorney, et cetera, et cetera. And again, we don't have all the details given that a large amount of the record is sealed, but it is obviously concerning, and this is what I would perceive as a conservatorship gone wrong. So These are, again, general rights that the conservatee has unless the conservator and or the court requests some other extended powers. And those additional powers kind of fall in a number of the areas of probate code. I just referenced 2590, which then references 2591 regarding the power for certain actions as conservator of the estate, whether you can sell real property or the personal residence without court confirmation, and a number of other, powers that are not default powers, but specifically associated with this particular conservatorship. And then with regards to the references to probate code sections 2351 through 2358, this deals a lot with conservatorship of the person requests and what a conservator can or cannot do. These probate codes will be provided within the materials, so I won't go kind of line by line regarding those, but I'll go into more of a conceptual understanding as it applies to Britney. So, as many of you know, a conservatorship it's individualized in a case-by-case situation. And so every case is different, every case is unique, every conservatee either has or does not have capacity to make certain decisions one way or the other. And the court must ensure that the conservatee's powers or the conservator's powers are tailored to meet the temporary or the general conservatee's needs measured by the best interest standard. As Costa kind of went into that, that's, probate code 1800, etc. Now, the court can only confer on the temporary conservator only those powers and duties that are necessary to provide the temporary care, maintenance, and support of the conservatee. These powers must be necessary to conserve and protect the property of the conservatee from loss or injury. Now, again, a general conservator has duties to assess the conservatee's needs, know the conservatee's rights, and ensure the conservatee is provided with the least restrictive possible environment. So again, importantly, the key here is that the conservator has a duty to know the conservatee's rights and to advocate, or otherwise it may be construed as a breach of fiduciary duties. So again, with conservatee's rights, without knowing what was said between the conservatee Britney and or her court-appointed attorney and or private counsel, we can only guess as to what the attorney stated to her, whether she or he properly explained her rights, whether she in turn expressly stated that she wanted this conservatorship terminated or wanted it to continue. That is for all of us to speculate. But moving on, then we're going to kind of focus on the role between a court-appointed counsel and that of a private counsel in the context of this conservatorship. And there's been a number of recent talks on this in various bar associations with regards to the role of the court-appointed attorney. And unfortunately, there is no kind of clear line, black letter rule or law of what the role is of the court-appointed counsel. So I'm going to spend more time focused on that, give you some case law, etc. Whereas as a private counsel, it's pretty straightforward. Your duties to advocate, your duties to confidentiality, to loyalty to your client, etc. So moving into the role of court-appointed counsel, it references probate code section 1470A. That is the section of the probate code that many of us, when we get appointed, whether it's in Contra Costa or otherwise, there's an order appointing counsel, and it'll say for all issues or for specific issues, etc. So the court must appoint legal counsel in one of two instances. First, if the proposed conservatee or a person alleged to lack legal capacity is unable to retain legal counsel and requests the appointment of counsel to assist in a particular matter. The court must appoint counsel as provided in probate code 1471. Alternatively, the proposed conservatee does not plan to retain legal counsel and has not requested the court to appoint legal counsel. The court must appoint counsel if it finds that the appointment will be helpful to the resolution of the matter or is necessary to protect the proposed conservatee's interests. And that's a reference code to 1471. So the provisions don't implicitly require when the court should or should not appoint someone. Wendland v. Superior Court, as I referenced, talks about when a court investigator's report recommends appointment of counsel, then the trial court is required to do so, whether the interests of the proposed conservatee interests are, at issue. So when the court investigator mentions, I believe that this individual needs a court-appointed attorney, the court will automatically and is required to appoint from whatever system that county has. So there's issues with regards to whether a report from an attorney who's court-appointed is in fact a report or is that a pleading, and what's the role or the goal of the report. And again, there's no line in the sand that says exactly what you're supposed to do. So I'm giving you kind of the different perspectives and legal authorities with regards to that and letting you, figure it out for yourself. So the court-appointed counsel typically reports to the court in a kind of bilateral way. The report may explain the proposed conservatee's wishes as well as counsel's opinion of the conservatee's best interests. The legislator has specifically provided for a balancing of both of these concerns by the court investigator, but it hasn't done that same thing with regards to court-appointed counsel. So without actual direction, courts must determine the role of court-appointed counsel in each county. So the role really depends on centers on two questions. How much of the conservatee's direction results from lack of capacity or undue influence rather than from sound mind? Again, it is important to determine whether you can create an attorney-client communication, whether the individual has the requisite capacity to express their intent one way or the other, or is that a byproduct of someone else's influence? And then secondly, what evidence suffices to answer that question before trial on a petition to establish conservatorship? So obviously, the more severe conservatee's impairment is, the greater weight that the courts will afford to the court-appointed counsel's opinion of the conservatee's best interests. And in contrast, the less impaired a conservatee appears in an area of deficit, the greater weight the courts give to the conservatee's express preferences. So here, right, we have Britney, again, whether she has capacity or not, the court really went off of what the court-appointed attorney recommended without actually speaking directly with, at least until recently, within the last 2 years, Britney. And so the court basically weighed heavily on what the court-appointed attorney stated, whether that was actually Britney's request or not. And, concerning is that for 13 years, Britney may have felt silenced and an inability to express what her wishes were and whether she had the requisite capacity to express those wishes to her attorney. Alarmingly, if she did in fact express those wishes and the court-appointed attorney did not then address those to the court sooner, whether year 6 or year 3 or year 10 of this conservatorship, the court-appointed attorney may be in a world of trouble. But basically, decisional kind of authority tends to support approval of court-appointed acting in the proposed conservator's best interests, even when such acts deviate from the proposed conservatee's expressed desires. So again, I just laid a few of these: conservatorship of Drabik, Wenlin. There's a few other conservatorship of John L. All of these are decisional authorities, either one way or the other, with regards to courts determining what the role is of the court-appointed attorney. And so, on the one end of the continuum is the conservatorship of Drabik, which is an individual who was in a coma, clearly unable to communicate in any way, shape, or form his or her desires to the court-appointed attorney, and yet the court had requested that the attorney make a decision with regards to the client's best interests. And the quoted line here is, the attorney must be guided by his own understanding of the client's best interest. There's simply nothing else the attorney can do. This is again supported by Wenlin, which went a little further with regards to the role of the attorney, court-appointed attorney. And then on the other side of the continuum is a proposed conservatee may not have any court-appointed counsel, and that's conservatorship of John L. The court need not appoint counsel in all proceedings to establish a conservatorship, because unlike in situations in LPS conservatorship, there's no risk of involuntary commitment. So the probate code does not universally mandate court-appointed counsel for probate conservatees. That's probate code 1470 and 1471. So again, this goes into the two sides of, when there is court-appointed and then what is the exact role. Again, moving on, an attorney's duty, whether it's court-appointed or not, is to protect his or her clients in every way possible. That goes back to Anderson v. Eaton. So, you always have to advocate. The question is, are you advocating directly based off what your client has expressed to you, i.e. in a role as a private counsel, or are you advocating on what you believe is in your client's best interest because your client is incapable of expressing his or her wishes? Again, applied here to Britney Spears' case, it's a bit shocking that that Britney is unable to express her wishes to her court-appointed counsel, and so it's very curious on my own end as a case study to see what, if anything, ever happens or will happen to court-appointed attorneys. Again, private counsel, duty to solely advocate, duty to loyalty, duty of confidentiality, all of these things that we as practitioners should know. Okay, so I've discussed, the difference of opinions on, what your role is as court-appointed attorney. I don't have an answer for you. Again, I leave it up to each person, and depending on the county, depending on the conservatee's ability to speak with you and in what capacity, whether they object to the conservatorship, all of these variables need to be taken into consideration. So with that, good luck. All right. With Britney, though, there's been rumors, at least in some form or fashion, that she had consented to the conservatorship, which is possible. A conservatee or proposed conservatee can consent in certain scenarios if she has the capacity to do so, etc. Now, I have here just a generic in reconservatorship of Britney Spears. This is very simple. Obviously, if this was the actual Britney Spears case, it'd be a lot more detailed. But if Britney, for example, had the capacity to consent to this, maybe because she understood from her father and her circle of advisors that she needs to be in this conservatorship at least for a year or so to kind of right the ship and to blah blah blah, then she could, in theory, have consented and or nominated her father or any other individual to serve in that capacity. It doesn't waive an individual's ability to terminate at a later day, but it does, take into consideration the conservatee's cognitive ability to consent to that. This is just an example. Lastly, with regards to terminating a conservatorship, you petition the court. And as the notice of conservatee's rights indicate, the petitioner, Britney here, by and through her counsel, whether it's court appointed or as private counsel, would have the authority to petition the court to terminate, whether it's regaining of capacity, whether it is a less restrictive alternatives, change in circumstances. What has occurred that has now indicated that this conservatorship is no longer necessary and that the conservatee has the ability to now properly take care of herself. So again, for closing remarks and the opinions on the Britney Spears conservatorship, I'm going to pass this back over to Kathy to give us the latest and greatest on the new bill that was just passed.
Thanks, Doug. Good job. So on September 30th, Governor Newsom signed into law a whole new Free Britney set of changes to conservatorship law. They're wide sweeping. We're tight for time right now, and I think it would probably be better if we discuss it either through questions or through afterwards if you have questions about it. The law is included in the packet, but just know that it is wide sweeping. It affects the appointment of private counsel. It affects the judge's job to investigate and terminate the conservatorship, and it affects fees and when somebody can actually get paid if something goes wrong with the conservatorship, if there's any objection to it. So with that, I'd like to thank everybody and toss it back to Ann.
Oh, I'm muted. There we go. Thanks, Kathy, and thanks, everyone. I'm Ann Wolf, and that's Emma. I'm with the Education Events Director for the CCCBA, and I want to thank Kathy and Doug and Costa for this great presentation. And I want to thank Sutter and Francesca for participating as well. We really appreciate them. What a great presentation. Thank you for shedding light on the bizarreness that is Britney. I think we can all agree that it's been interesting and will continue to be. So I'd like you to stay tuned for the live Q&A coming up right after the announcements. I want to just let everybody know that the materials and evaluation forms for this program can be downloaded from the session page through the Files tab in the chat. It's above the chat. And the attendance certificates will be available after Thanksgiving. If you're a CCCBA member, they'll be in your attendance certificate the attendance certificate tab in your My Profile page. And if you're a non-member, check the FAQ tabs for how to get your attendance certificates. Also, for assistance with technical difficulties, please see the FAQ tab. So now let's all click on the link that's below this screen and pop into the live Q&A. We can get all the questions answered. So I'll see you all there. Thanks so much, everybody.